Juliette and I are very happy to be with you today to speak about harmonization of rules of private international law concerning the commercial, digital, and financial sectors. During our presentation today, we'll dive into the metaverse. I hope that you're ready. We will focus on the private international questions that may arise in case of disputes relating to metaverse transactions. Before entering into details on the issues of applicable law and competent jurisdictions, as well as the issue of enforcement of metaverse-related decisions, it is important to first define the term metaverse and the key features of metaverse transactions. So, what is the metaverse? This term is everywhere. It has become this year one of the biggest buzzwords in the tech world. This is because the metaverse is widely expected to be the next internet revolution. For those that live in a cave or that are allergic to tech, the metaverse is basically a virtual environment you can enter instead of just observing it on a screen. In the metaverse, you can, or soon will be able to, work, play, socialize, buy and sell goods. There are not one metaverse, there are dozens of metaverse. The biggest ones are Decentraland or the Sandbox. What makes the metaverse special nowadays as compared to interactive games or social media is the ability to own and buy digital assets. As in the physical world, people are interacting and transacting, but in a different manner. This means that with the metaverse, a new civil society is actually built. This new civil society needs to be civilized. As we will see, the rules of private international law are insufficient or not adapted to this new environment. A legal order needs to be created, a new one. And to do so, as legal practitioners, we need to understand the special features of the metaverse and the transactions that can be performed in this virtual environment. We will therefore turn to the key features of metaverse transactions. The very nature of the relationship between persons in the metaverse are very different than in the physical world. Simple questions such as who, what, when, or how have different answers when transported to the metaverse. Let's try to give an answer to these simple questions, to these apparent simple questions. Who is in the metaverse? To access the metaverse, individuals have to create their own avatar. And by doing so, users create their virtual identity. What is really important to understand is that the individuals that are behind these avatars might stay completely anonymous. As we will see, the anonymity of the person with which you are transacting raises several private international law issues. For example, how can you determine the competent jurisdiction if you don't know the identity of the person behind the avatar? We'll try to answer these questions later. What can you do in the metaverse? You can purchase goods and services. They can be both physical or digital. For example, in some metaverse platforms, avatars may be able to order takeout food or buy books and have these delivered to their physical locations. We could already do that with the internet. The real innovation is that users can offer virtual services to others, such as gaming experience or concerts, and user can also create and offer other users to buy virtual goods. And they take the form of NFTs. For instance, you can buy virtual clothing for your avatar. These are called wearables in the metaverse. You can buy artworks for your home in the metaverse. Last but not least, you can also buy parcels of land in the metaverse, and then, for example, rent them. The volume of transactions in the metaverse of virtual goods and services has skyrocketed. To give you an idea, the total volume of virtual real estate transactions reached 500 million of US dollar in 2021, and it is expected to double in 2022. Just as in the physical world, payments in the metaverse can be made in various ways, but the most common one is via cryptocurrencies. All these transactions can be regrouped in two main categories. On the one hand, transactions among users only, and on the other hand, transactions between a user and the metaverse platform. Disputes arising out of these two categories of transactions are subject to different legal framework. We will see that later on. Because this legal framework will have an impact on the questions of, for example, jurisdiction and applicable law. The next question is, where does a metaverse take place? A metaverse takes place in the metaverse. This is not surprising, but what does it mean? The metaverse is dematerialized and the transnational environment. As for internet, the metaverse has no border. The fact that the metaverse transactions are executed on a blockchain adds another layer of complexity. Blockchain is decentralized. This means that there is no central place where the blockchain is located. Blockchain nodes, that is usually computers participating in a blockchain network, are located all across the network. What is also very important is that there are two main kinds of metaverse platforms. Those controlled by a central authority. This is, for example, the case of Fortnite or Roblox, and those that are decentralized and that are built and established by communities. This is, for example, the case of the Sandbox and Decentraland. In this case, the worldwide community of users is at the core of the metaverse. It is not the metaverse company that is at the core of it, and that is very important. Therefore, as a general rule, the use of the metaverse is enough to give the transaction an international scope. We consider that a transaction performed in the metaverse is, by definition, an international transaction. There is therefore for all metaverse transactions a potential conflict of laws from different states. Furthermore, all these key features of metaverse transactions, dematerialization, decentralization, transnational environment, are key, as we will see, to determine the connecting factors of private international law to be applied to metaverse transactions. I will now give the floor to Juliette.
So the next question was when? Time, as we know it, does not exist in the metaverse. So you cannot program something in the metaverse for a specific duration of time. Instead, you program it for a number of blocks on the blockchain. And another specific feature in the metaverse is that it has no intrinsic day or night cycles. It operates 24 hours of a day. And the last question is how? How do transactions in the metaverse work? In the Web 3.0 world, most transactions are executed through smart contracts. And this is also the case in the metaverse. This term is confusing, and I would like here to make a short clarification. Contrary to all appearances, a smart contract is not per se a legal contract. A smart contract is merely a computer code based on the blockchain technology that automatically executes and enforces predetermined conditions. So smart contracts run according to a series of if-then statements. So if event X happens, for example, a payment is made, then Y occurs, for example, an NFT is transferred. So rather than contracts per se, smart contracts are digital mechanisms for self-executing and self-enforcing transactions without human intervention. Having said that, there is a misconception that because smart contracts execute a transaction automatically and performance cannot be stopped, they remove the potential for disputes. And at least for the moment, I think this is wishful thinking. First, not all contractual obligations can be coded into a smart contract. And second, disputes may derive from the performance of the transaction. So the code itself may contain an error. For example, there is a risk that the developer can enter the wrong crypto wallet address when programming the smart contract, and then the money is transferred to the wrong person. Or the code might fail to correctly reflect the intention of one of the parties. For example, you might receive digital Nike shoes for your avatar, which do not have the color you thought when you bought them earlier in Nike's flagship store in Decentraland, one of the metaverses. Or you might receive a digital Chanel blazer or a Cartier Love bracelet for your avatar, but it ends up being a counterfeit. And lastly, bugs from metaverse platforms might also occur. And for example, because of a technical glitch, you may fail to access a concert for which you had bought a ticket. And this can also be a source of disputes. So now I give back the floor to Laura.
Thank you, Juliette. So now that we understand better how the metaverse works technically, let's turn to the private law questions that may arise in case of dispute arising out of a metaverse transaction. For the purpose of this presentation, we will focus on contractual disputes. So the first question, what is the current legal framework? There are, to our knowledge, no private law rules adopted by one or several states in relation to the metaverse in particular. Moreover, there are no uniform rules of law at the international level specifically for the metaverse. The question is therefore, are there uniform rules at the international level that may apply by analogy to metaverse transactions? The rules of law adopted for transactions carried out on the internet could, when they exist, be applied by analogy. even if these rules were not adopted for the metaverse and they were adopted when the metaverse did not exist. However, the nature of a transaction, of a metaverse transaction, is very different from e-commerce, as we have seen now with the key features of metaverse transaction. So applying these rules would not necessarily be suitable for metaverse transactions. The question of jurisdiction. From a private international law perspective, the first question in case of dispute is to determine where a claim deriving from a metaverse transaction can be brought. This is not an easy question in the current legal framework. It is possible to get around the difficulty of this question by allowing the possibility of a choice of court agreement. In practice, we find choice of court agreements only in one of the two categories of transactions that we have identified, those between a metaverse and its users. In fact, the terms of use of the metaverse that any user must accept to access the metaverse generally include a jurisdiction clause in case of dispute. This is the case, for example, for Decentraland, which provides for arbitration seated in Panama. Axie Infinity provides for arbitration seated in the Cayman Islands. It is, in fact, common to find arbitration clauses in the metaverse terms of use. Some metaverses, however, also provide for the jurisdiction of national courts. For example, the Sandbox provides that the Court of Hong Kong are competent. The metaverse terms of use are, however, silent on the dispute resolution mechanisms among users. And in practice, no choice of law clause is entered into among users, at least not before any dispute. This is due to the way most metaverse transactions are executed, using a smart contract only. As a general rule, no traditional written contract is concluded among metaverse users. Although it would technically be possible to code in a smart contract a choice of law clause, but in practice, users do not do it. I think that users probably do not see the necessity of doing it. However, absent such a clause, users might face legal challenge to determine how and where to assert their rights in case of disputes. Assuming that there is a choice of court clause, the question is whether it is valid. Depending on the jurisdiction, several instruments might find application. This is in particular the case of the Hague Convention on Choice of Courts Agreement of 2005. This convention should be sufficient to determine the validity of choice of courts agreement in relation to the metaverse, even though it is not expressly provided, and obviously such a technology did not exist at the time. This convention requires that a choice of court agreement must be concluded or documented in writing or by any other means of communication which renders information accessible. These requirements seem to be suitable for metaverse transactions. A progression of jurisdictions specified in the terms of use and entered into electronically meets such a criteria. This is also the case in case it is coded in a smart contract. Since a great number of disputes are likely to be resolved by way of arbitration, it is important to note here that there are currently some uncertainties as to the effectiveness of an arbitration clause exclusively coded in a smart contract. Whether users are deemed to have consented to the code will depend on each case and the parties involved. What is sure is that those with no coding background cannot easily interpret a smart contract. Absent a valid choice of court clause, the question is how to determine the competent court. A connecting factor typically used in private international law is the place of residence, place of business, place of domicile of the defendant. This traditional approach, however, needs that the defendant can be identified, which is not necessarily possible in the context of a metaverse transaction. The question is therefore what additional factors should apply. The forum at the place of performance of the contract might be an option, but we face with another difficulty: how to determine the place of performance of a metaverse transaction when this transaction is performed via smart contract in a dematerialized and decentralized environment. Locating the performance of the contract in a state jurisdiction rather than in another is actually virtually impossible, as the performance takes place everywhere and nowhere at the same time. What about a connecting factor related to the metaverse? Since the metaverse is based on a blockchain with nodes all around the network, the location of the metaverse from a technical standpoint does not seem to be an option. What about then the seat of the metaverse company? This could be an option, as the location can be identified, but this solution might not seem satisfying for decentralized metaverse, in particular where the community controls the metaverse and not the central authority. In this respect, the seat of the metaverse company does not seem to be a good option. This overview leads us to an important conclusion. One cannot find a suitable objective connecting factor of private international law for metaverse transactions because the metaverse has no closest connection to any jurisdiction. Our current legal system is based on geography, because that is the physical world we live in. But this is not the world we are moving into, the metaverse world. The geographical location of a metaverse transaction is meaningless. As we have seen in the metaverse, identity, location, or time are very, very fluid concepts. This is why we need to adapt the connecting factors of private international law in order to take into consideration the specific features of metaverse transactions. So, what is the solution? We consider that it might be justified to allow a claimant to bring action before the court of the defendant, but also before the courts of its own domicile. This solution has been suggested in the context of blockchain transactions, and it seems to be adapted to the specific features of metaverse transactions. Let's now turn to the applicable law. As with jurisdiction, the easiest solution is to allow the possibility of a choice of law agreement, which can be provided in the terms of use of the metaverse or of the users in traditional contract or coded in a smart contract. Depending on the jurisdiction, while determining the validity of such clause, it is important to keep in mind that the consumer protection rules may limit or exclude the possibility of making a choice of law. It will have to be determined whether such protections should be applied as such for metaverse transactions. The question is which fallback rule can be provided in the event that no valid choice of law is made? What is the most appropriate connecting factor defining the applicable law? Again, we faced with the impossibility of establishing the closest connection to any jurisdiction of metaverse transactions. Only conflict of law rules independent of any location criterion are able to provide a satisfactory connection to a national legal order. A solution which has been suggested in the context of blockchain technology is to apply the lex fori, that is either the domicile or place of business of the claimant or of the defendant. This seems to be a wise solution. To conclude, the adoption of private international rules designed specifically for legal relationships formalized via the metaverse or potentially blockchain in general would ensure predictability and legal security. This is therefore absolutely necessary. These rules should promote party autonomy, and this is in line with the spirit of Web3, where the control is given to users. This means that one should leave as much room as possible for choice of law and choice of court agreements. Moreover, in the absence of such agreements, the connecting factors should be based on the place of domicile or business of the parties to the transaction. I will give the floor to Juliette.
So I will try to be very short because there are only 2 minutes left, but I hope that Harry, maybe I can have a slightly more. So the last topic is a recognition and enforcement of metaverse-related transaction. Traditionally, a judgment or an arbitral award can only produce legal effects in a given national system once it has been recognized and enforced. So states, therefore, traditionally have the possibility to control the enforcement of foreign judgments on their territories. However, it is now also possible to use the smart contract technology to automate the enforcement of judgments and arbitral awards, what we call on-chain enforcement. So this constitutes a major shift in our judicial system. States do not have any control over the enforcement of this decision. Concretely, parties to a dispute can agree to deploy a smart contract on a digital escrow and to deploy a smart contract that will be automatically enforced once the decision is rendered by the tribunal. This entails a prior deposit by all the parties of the amounts at claim on the digital escrow. The smart contract, which is linked to the outcome of the decision, will, for example, provide that if decision states that party A wins 100 Ethereum, then 100 Ethereum will be transferred from party B's crypto wallet to party A's crypto wallet. So, of course, it will be in a slightly more sophisticated programming language, but that's basically it. So the winning party thus does not need to seek enforcement of the decision. It is all automatic. And this constitutes a major change because some private decisions can now be enforced on a state's territory without any control from that state. However, all metaverse-related decisions are not automatically enforced via smart contract. And for example, smart contract can only transfer digital assets that are defined on the blockchain such as cryptocurrencies or NFTs. So it does not work if the remedy stipulated in the decision is not digitally executable. So where automation has not been foreseen, the other possibility to enforce a decision rendered in a metaverse-related dispute is to go before the state courts. So this is the traditional way that we call off-chain enforcement here, as opposed to on-chain enforcement. Off-chain enforcement raises specific private international law questions due to the specific nature of metaverse-related transactions that we listed earlier. The first question that arises is where to initiate recognition and enforcement proceedings. This is not an easy question. Imagine you have had a dispute in the metaverse, for example, regarding the purchase of a piece of land in the sandbox, or regarding the purchase of a pair of shoes for your avatar from Nike's flagship in Decentraland. In which country would you start recognition and enforcement proceedings? Traditionally, one starts proceeding where the assets are located. But the question of the location of the assets here is not easy. Cryptocurrencies are arguably one of the most common assets in the metaverse. Related transactions are dematerialized. They are kept on a digital wallet, which is either stored on an online platform, on a computer desktop, or on a hardware. But the location of the wallet seems to be too artificial to constitute a useful connecting factor of private international law. So how can we define the location of cryptocurrencies for enforcement proceeding purposes? UK courts have found that under English law, the location of a crypto asset is likely to be the place where the person who owns it resides or is domiciled. The domicile of the owner, in my view, seems to be a straightforward solution, at least more straightforward than having to establish an artificial link between the crypto asset and, for example, the location of the servers where the crypto asset has been mined or where the private key is held. So the same issues arise for NFTs, and this solution could also be a straightforward solution. But what is crucial is that we have some harmonization between the states. Some guidelines or rules would therefore be helpful, and using the domicile or residency of the digital assets owner could be an easy solution. Once you have established where to start recognition and enforcement proceedings, you then need to see what are the criteria for the states to recognize and enforce your judgment or award. And international arbitration awards must follow the criteria of the New York Convention, and foreign court decisions must satisfy the criteria of various applicable conventions. Brussels 1 bis, Lugano, the Hague Judgment Convention. I'm sure you saw this convention just made the headlines 2 weeks ago. Or national private international laws where no convention is applicable. So I have attempted to identify, and I will go quickly because I know I'm running out of time, to identify some issues that may be raised at recognition and enforcement stage when applying these criteria for decisions rendered in the context of metaverse-related disputes. So one potential issue is due process. So the New York, Hague, Lugano, and Brussels 1 bis conventions all provide that the recognition of the decision can be refused where the party against whom it is invoked was not given proper notice of the proceedings. So this could be an issue in case of default proceedings, for example, rendered against an avatar, where it is not possible to identify the person or entity behind the avatar in the physical world, thus denying this anonymous person the opportunity to present this case. One question that arises here is whether alternative means to notify the start of proceedings to defendants could be found. For example, we could think of notifying a party by airdropping an NFT containing the documents to be served to the other side's crypto wallet. In this respect, by the way, a recent court decision in the UK granted permission for service of proceedings to be effected by NFT in a case of fraud. Another potential issue is incapacity. The New York Convention provides that the recognition of the award can be refused where the parties to the arbitration agreement are under some incapacity. the user behind an avatar could be a 13-year-old individual in the physical world, or it could be someone incapable. It could even be a machine. So the question that arises here is whether this rule of the New York Convention should be applied strictly for disputes arising out of metaverse-related transactions. Another potential issue is public policy. So all conventions provide that states can refuse recognition and enforcement of decisions that are contrary to public policy. And one question that arises is whether a decision ordering the transfer of cryptocurrencies could be seen by some states as contrary to public policy. And here I have in mind the recent banning by some countries of cryptocurrencies, such as China. Some country who want to control their citizens could, for example, ban some metaverses or some blockchains. So could transactions concluded there be regarded as contrary to public policy by certain national courts? And last issue, and I promise then I'm almost done, is the form of the arbitration agreements, which is this criteria is only applicable for international arbitration awards, not foreign judgments. The New York Convention provides that for an award to be enforceable, the arbitral clause of the original contract must be in writing. And it further provides that it must be signed by the party or contained in an exchange of letters or telegram. So it remains here to be seen how courts will interpret this provision and whether they will adopt an arbitration-friendly approach and find that arbitration clause solely coded into a smart contract meet that criteria. So to conclude our presentation today, to ensure sufficient predictability and legal certainty, it is of utmost importance to have clear answers to fundamental questions such as jurisdiction, applicable law, and enforcement of metaverse-related disputes. The answers need to be based on the specific contours of the metaverse, a decentralized, dematerialized, virtual world in which anonymous avatars are transacting. Thank you very much.